1. Introduction: Why understanding Canadian privacy law is crucial. In today's digital age, protecting your personal information has become more important than ever. With the increasing amount of data breaches and cyber attacks, it is crucial to understand the laws and regulations that govern privacy in Canada. Canadian privacy law is designed to protect individuals' personal information from being collected, used, or disclosed without their consent. By understanding these laws, you can take steps to safeguard your personal information and avoid potential risks and consequences. In this article, we will explore the principles, enforcement, and future developments of Canadian privacy law, as well as the importance of complying with these laws. 2. The principles of Canadian privacy law: what you need to know. In Canada, privacy law is governed by a set of principles that outline how personal information should be collected, used, and disclosed. These principles are based on the idea that individuals have a right to control their personal information and that organizations have a responsibility to protect it. The principles of Canadian privacy law include accountability, consent, limiting collection, limiting use, disclosure and retention, accuracy, safeguards, openness, individual access, and challenging compliance. Accountability means that organizations are responsible for complying with privacy laws and must designate someone to oversee their privacy practices. Consent requires that individuals give explicit permission for their personal information to be collected, used, or disclosed. Limiting collection means that organizations should only collect the information necessary for their purposes. Limiting use, disclosure, and retention means that organizations should only use, disclose, and keep personal information as long as necessary. Accuracy requires that organizations take reasonable steps to ensure that personal information is accurate. Safeguards mean that organizations must protect personal information from unauthorized access, use, or disclosure. Openness requires that organizations make their privacy policies and practices publicly available. Individual access means that individuals have the right to access their personal information held by an organization. Challenging compliance means that individuals have the right to challenge an organization's compliance with privacy laws. Understanding these principles is crucial for protecting your privacy in Canada. By knowing what organizations can and cannot do with your personal information, you can make informed decisions about who you share your information with and how it is used. 3. Enforcement of Canadian privacy law: how it works and what to expect. Enforcement of Canadian privacy law is a critical aspect of protecting your personal information. The Office of the Privacy Commissioner of Canada, OPC, is responsible for enforcing the Personal Information Protection and Electronic Documents Act, PIPEDA, which regulates how private sector organizations collect, use, and disclose personal information in the course of commercial activities. The OPC has several tools at its disposal to enforce PIPEDA, including conducting investigations, making recommendations, and taking legal action. If an organization is found to be in violation of PIPEDA, the OPC may issue a compliance agreement or take the matter to the Federal Court of Canada. It's important to note that PIPEDA only applies to private sector organizations engaged in commercial activities. Public sector organizations, such as government agencies and departments, are subject to different privacy laws and enforcement mechanisms. If you believe that your privacy rights have been violated, you can file a complaint with the OPC. The OPC will investigate the complaint and determine whether the organization in question has complied with PIPEDA. If the OPC finds that the organization has not complied with PIPEDA, it may make recommendations or take legal action to ensure compliance. Overall, understanding how enforcement of Canadian privacy law works is crucial for protecting your personal information. By staying informed and knowing your rights, you can take steps to safeguard your privacy and hold organizations accountable for any violations. 4. Recent developments in Canadian privacy law: what's changed and what's next. In recent years, Canadian privacy law has undergone significant changes and developments. One of the most notable changes was the passing of the Digital Privacy Act in 2015, which amended the Personal Information Protection and Electronic Documents Act, PIPEDA, to include mandatory breach reporting requirements for organizations. Another important development is the ongoing review of PIPEDA by the federal government. The review aims to modernize the legislation to better address current privacy concerns, such as the use of artificial intelligence and big data. Some proposed changes include increasing transparency requirements for organizations and giving individuals more control over their personal information. In addition to these legislative changes, there have been several high-profile privacy breaches in Canada that have highlighted the need for stronger privacy protections. For example, in 2019, Capital One experienced a data breach affecting over 6 million Canadians. This incident led to calls for stricter regulations and greater accountability for organizations that fail to protect personal information. Looking ahead, it's likely that Canadian privacy law will continue to evolve in response to new technologies and emerging privacy risks. As individuals become more aware of their privacy rights and demand greater control over their personal information, organizations will need to adapt to stay compliant with the law and maintain consumer trust. 5. The importance of complying with Canadian privacy law, risks and consequences. Failing to comply with Canadian privacy law can have serious consequences for individuals and organizations alike. For individuals, the risks include having their personal information mishandled or misused, which can lead to identity theft, financial fraud, and other forms of harm. For organizations, the risks include fines, legal action, and damage to reputation and customer trust. Under Canadian privacy law, individuals have the right to access and control their personal information, as well as the right to know how it is being collected, used, and disclosed. Organizations that collect, use, or disclose personal information must obtain consent from individuals and take steps to protect that information from unauthorized access, use, or disclosure. Failure to comply with these requirements can result in penalties ranging from fines to legal action, depending on the severity of the violation. In some cases, organizations may also be required to notify affected individuals if there has been a breach of their personal information. In addition to legal and financial consequences, failing to comply with Canadian privacy law can also damage an organization's reputation and erode customer trust. With data breaches and privacy violations making headlines on a regular basis, consumers are becoming increasingly aware of the importance of protecting their personal information and are more likely to take their business elsewhere if they feel their privacy is not being respected. Overall, complying with Canadian privacy law is not only a legal requirement but also a crucial step in protecting both individual privacy and organizational reputation. By taking proactive steps to understand and comply with privacy regulations, individuals and organizations can help ensure that personal information is handled responsibly and ethically. 6. Conclusion: taking action to protect your privacy in Canada. As Canadians, we have the right to privacy and the responsibility to protect it. Understanding Canadian privacy law is crucial in achieving this goal. By knowing the principles of Canadian privacy law, how it's enforced, recent developments, and the risks and consequences of non-compliance, we can take action to safeguard our personal information. To protect your privacy in Canada, start by being aware of the information you share online and with whom. Be cautious when giving out personal information, especially on social media platforms. Use strong passwords and enable two-factor authentication whenever possible. Keep your software up to date and use antivirus software to prevent hacking and malware attacks. If you're a business owner, ensure that you comply with Canadian privacy laws by implementing appropriate policies and procedures. Train your employees on privacy best practices and conduct regular audits to identify potential vulnerabilities. In conclusion, protecting your privacy in Canada requires knowledge, awareness, and action. By taking steps to safeguard your personal information and complying with Canadian privacy laws, you can help create a safer and more secure digital environment for yourself and others.